Thank you, Mr. President. Your Honors. The systematic interpretation of Article 18 and Rule 52, Paragraph 2 is the following. Article 18.1 is an act aimed at coordinating the international community as a whole. Hence, the express indication that the notification is addressed to states parties and all those who would normally exercise jurisdiction over the crimes concerned, indicating to them, of course, the specific acts to be investigated. It would be a mistake to think that notification under Article 18.1 is addressed only to the state in whose territory the acts were committed. We must not forget that multiple criminal jurisdictions may be established in the international community in respect of one act. Territorial jurisdiction, jurisdiction by active personality, passive personality jurisdiction, protective jurisdiction, and of course, universal jurisdiction. In drafting the Rome Statute, states established procedures to ensure the principle of complementarity and the primacy of national jurisdictions. One of them was that the notification of Article 18.1 should be made to the entire international community. In this way, all states can report within 1 month whether their jurisdiction is investigating any of the specific cases set out in the notification, whether by territorial jurisdiction, active personality, passive personality, protective jurisdiction, or universal jurisdiction. And thus, all states of the international community that are notified of the specific cases can trigger the second step and approach the OTP on the basis of Rule 52, Paragraph 2, to seek further information of the specific cases that that state is investigating or has prosecuted. Therefore, the notification of Article 18.1 is a call for coordination among the jurisdictions of the international community in relation to potential cases to be investigated, so that the notification must include specific cases. And thus, Rule 52, Paragraph 2 becomes only a tool to complete information vis-à-vis bilateral between the OTP and a particular state seeking to know more about a case or cases notified under Article 18.1 that are under its jurisdiction. This is the systematic interpretation of both provisions. However, the notification of Article 18.1 without specifying cases in the situation of Venezuela breaks with this logic. This notification did not include specific cases, so states of the international community could not effectively know whether any of the cases that the OTP intends to investigate were already under its jurisdiction. Only Venezuela resorted to Rule 52, Paragraph 2, so only this jurisdiction had access to Annex 2, which sets out a list of incidents. The other states of the international community are still unable to inform the OTP whether or not they are hearing the same cases, because they were not duly informed in the Article 18.1 notification. And I'm not talking about speculation. I will give a concrete example. Not long ago, it was reported in the press that alleged Venezuelan victims had applied through the principle of universal jurisdiction to the Argentinian courts. However, due to the incorrect notification of Article 18.1 without exposing to the international community the specific cases over which the jurisdictions of the world must coordinate, Argentina has not been able to know whether its case is a mirror image of one of the cases that the OTP intend to investigate. Of course, Rule 52, Paragraph 2, and the transfer of specific incidents in Annex 2 was carried out vis-à-vis Venezuela. So Argentina has not been aware of these incidents and could be violating non bis in idem, as well as being in breach of the principle of complementarity. Your Honors, if this appeals chamber confirms that an Article 18.1 notification to states parties and jurisdictions involved could be made without including concrete cases, it would set a precedent contrary to the spirit of coordination of the jurisdictions of the international community that resides in the Article 18.1 notification. The result would be multiple national proceedings overlapping with the ICC without regard to complementarity, along with violations of the principle of non bis in idem. Thank you. If you agree, Mr. President, I will give the floor to my colleague, Mr. Marchand.